Whatever you might be going through and wherever you might be, this is Omar Serrato with the Tilted Lawyer Podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started.
Happy Friday to you folks. This is Omar Serrato with the Tilted Lawyer Podcast, and I've been wanting to talk about Karen Reed. She is on the cusp of trial number 2, and I gotta say, I am extremely nervous for what is to come for Karen Reed. I gotta tell you, I wasn't involved in the first trial, but I was closely following it like a lot of you. I had questions regarding the evidence, the same as all of you. And when I saw some of the missteps in the chain of custody things that were happening, like collecting evidence in like one of those red Solo cups that you would find at college dorm room parties nationwide, worldwide really. Some of the inconsistencies, some of the phone records, some of the autopsy findings, the fact that there was an entire FBI investigation that had concluded that John O'Keefe's death was not consistent with being hit by a car. There was a lot of questions, and then we think that we're coming to some kind of a resolution. I recall critiquing the prosecution's performance in that initial trial and just thinking that it was lackluster. I thought that the evidence was weak. I thought that the evidence was sloppy. I thought that where reasonable doubts is supposed to be exculpatory, I thought where reasonable doubt is supposed to rule the day, that there was plenty to go around with respect to this Karen Reed case. I thought that her text message communications, her on-the-scene encounters with law enforcement and others, some of which was recorded, some of it which was not, really sold the story of a lady that she really didn't know what had happened. And to really understand why that was, you have to go back to the events of that night. We're going to revisit that timeline. We're going to revisit it just to rehash, just to review. I don't know how many of you guys have been following this case for the last year since we've been on this path to second trial, but there was a whole freaking documentary that came out where Karen Reed was having communications with her attorney, and I know that the prosecution is going to try to spin some of those statements as potential consciousness of guilt. Specifically, there was a portion of that documentary where Karen asked her attorney, openly and earnestly, like, what if I ran over his foot? Like, what would be the result of that? It's like, well, then you would have liability there. And then I know that they had discussions about trying to potentially bring that in as guilt, consciousness of guilt evidence at this second trial. I've been very suspicious of some of the decisions that this judge has made. I was very disappointed in the way that she allowed the trial to just go to mistrial. It seemed, not just to me, but it seemed to many of you that were monitoring the case and monitoring the way that the jury was examining the case through the jury notes to the courts, that it really felt like they were in agreement on some of the more major issues. You know, vehicular homicide, first degree, second degree murder, all those kinds of things. They were hung up on several other issues, but they were never polled. And they never got to actually have any discussion or let the judge know that, look, it's not that we're just undecided on every single issue. We're in agreement on some of this big stuff. It's these little things. And this judge, rather than polling the jury, which she was not constitutionally required to do, by the way. So she was well within the rules when she decided to grant the mistrial. That should be made fundamentally clear. But she could have told the jury is the point. Like, we spent years getting to the point where we're at the moment of verdict. And then she just allows it to go to mistrial. And now we have this second trial. There was some speculation. Oh, I don't know if the prosecution really wants to re-pursue this entire case, given how weak all of the evidence was at trial and how it was an embarrassment upon the Commonwealth, how sloppy the investigation was as it proceeded, the chain of custody stuff, the embarrassing admissions that were made on the stand by some of the law enforcement officers. Do they really want to go through all of that again? Well, the answer was a quick and swift yes, they do. And they have. And now here we are on the eve of trial number 2. And so let's take a look at I'm just going over some of my old notes. So as you guys recall, what we know about the prosecution's theory of the case is that John O'Keefe, that was the victim in this case, he lost his life on that night, whether you think it was because Karen Reed ran him over, whether you think it was because he got beaten up by some of the people that were inside the house, who were involved in a love triangle between O'Keefe, Karen Reed, and themselves, out of some kind of who effing knows, man. I know that I've seen pictures, and all of you have likely seen pictures where on his arm it looked like it was shredded by frickin' Wolverine. And it's like, wait a minute, I thought he died because he got hit by a car and died from the elements. What are all these scratches from? Dog bite evidence. There was experts that kind of testified to some of those things. The prosecution's theory was that John's injuries and the evidence at the scene pointed to a vehicular impact. And they had pointed to damage to Karen Reed's vehicle. They highlighted that there was head trauma that they claimed, and their experts tried to claim, was consistent with either hitting the ground or a car, one of the two. And one of the big expert battles was, you could not have possibly gotten those kind of head injuries from getting struck by a tail light at that low of speed. It's more consistent with something else, perhaps hitting the ground. And there was a whole day or two of a trial testimony that was devoted towards the end of trial number 1 to that singular issue. The experts from the defense said that it kind of looked like that injury was a lot more consistent with hitting the ground or somebody's head hitting the ground. There were cuts on the body that the prosecution argued were consistent, having obtained them from glass or plastic from the tail light. They argued that the pattern of injuries, there wasn't any broken legs. I forget if there was any broken bones at all, but there wasn't any major injuries, is what I can recall. That the pattern of injuries, the prosecution said, could occur if he was knocked over just in the wrong way. It was icy, it was snowy, whatever, the ground was hard. They presented evidence and claimed that O'Keefe's DNA was on a broken taillight and that his hair was on Reed's car. And there was near irrefutable proof that her SUV hit him because of all of these things. Just connect the dots. There was video that was examined of Karen Reed backing out of her driveway, and as she's on the way to the scene, and all these kinds of things. What else did they say? They said any alternate scenario fails to explain this physical evidence, but that there was alternate theories abound. It's like, well, wait a minute. Okay, so how do you explain then the arm injuries? It literally looks like, look, I could see broken shards of glass or whatever, broken pieces of the tail lights, but no expert jumped on the stand and said that those injuries were consistent with like shattered glass or something that would have tied what we were looking at in terms of their presentation of evidence and their theory of the case. Nothing tied into it. And then the defense is like, yo, Karen didn't hit him. His injuries were not consistent. The guy's got like 2 broken eyes. He's got a fractured skull. He's got all of these minor superficial injuries. It looks like he got his ass beat down and was left for dead in the elements. That's how he died. The problem with that was it was really difficult for the defense to proceed with that theory of the case without being able to introduce evidence of third-party culpability. The judge basically said, look, I'm not going to allow you, unless you're saying somebody specific, to implicate anybody or just randomly say that it could have been somebody else. If there's a specific piece of evidence that you want to point to and tell us how they're tied and how they are actually the ones guilty of this death and not your clients, then you got to actually just say that. The defense never actually just came out and said it. They implied, they did an awful lot of implication through cross-examination testimony, but they never actually reached the point where they just outright accused anybody else of the crime, namely the people that were in that house. He's going to have the same problem in the second trial. Because look, the obvious defense is Aaron Reed didn't do it. He died from some other reason. Whether that be that he fell and slipped and hit his head and nobody did it. I guess that's kind of the problem, isn't it? It's too speculative. But he's got these injuries. He's got all this kind of stuff. Yeah, we know. The defense says too many injuries. They do not line up with a low-speed car bump, which is what the prosecution said. He had 2 black eyes. They had brought out an expert that said that when somebody has raccoon eyes like that, it's more indicative of somebody suffering from head trauma, from a frontal assault, or a skull base fracture, consistent with getting in a fight and getting your ass kicked. And there just so happened to be in that house a cop who was well versed in boxing, I think it was, some kind of combat sport. But they never really tied it in. They never explicitly said that the death was because of something like that, because they didn't have the evidence tied it to him. And, you never want to, as an attorney, just like throw random shit out there. They have this theory, they have this evidence, but no matter how much evidence you put out there, it doesn't directly lead to anybody. And maybe there's a simple explanation for that. But they have to frame it. I don't know how they're going to frame it, but, the prosecution's saying that these injuries are the result of a car accident. Fine. But the injuries don't seem to be, and there's been experts who have concluded that this is not consistent with the car accident. They've been wanting to get in this FBI investigation that concluded that the death was not consistent with what the prosecution says that it was, basically. They had asked the question, why a deep wound? Like, what was with the wounds to the arm? Okay, so it was hit by a car. Where did these scratches come from? Was it from a dog attack? Was it from a dog bite? Multiple dog bites? That was a big question in trial number 1. They had brought in experts from an accident reconstruction and pathology field that had testified that the damage on Reed's SUV was not sufficient enough to cause severe head trauma that O'Keefe had sustained, which is problematic. And I personally think, that evidence was compelling to me. The guy gives his credentials. He gets up there and says, I investigated 100 of these kinds of crimes. And he had these specific formulas for how he assessed injuries and damage to cars. And he just says, look, it doesn't look consistent. This level of head trauma does not look consistent with the damage that's on that car. It would make no logical sense to me. And he had reasons for that. In other words, the physics do not match. And if the physics don't match, and that's the theory that the prosecution is rolling with, then you have to find him not guilty. If that's the only theory of the case that supports guilt, and it's not physically possible, then you must acquit. That was the issue. And I think that the jury was buying it. And I personally think that the jury was prepared to acquit Aaron Reed of the murder charges. They were just hung up on other stupid shit. But the judge never bothered to pull them, so we'll never know. There were jurors that came out after the fact and said, dude, we weren't really all that far apart. It was just like this minor stuff that we had hangups on. But then they came out and had this letter. It's like, well, we're just never going to agree on some of these smaller issues. We are morally set in our ways. It was something like that, some kind of biblical language to that effect. We are too morally set in our positions, and we're not going to ask each other to compromise our morals for the sake of bending to the other side because of principles. Whatever, man. So the judge not polling the jury, we will never get to see what they were actually thinking. I mean, we could hear bits and pieces of it here and there, but, it is what it is. There was a suggestion that O'Keefe's skull fractures could have been formed from repeated blows or a high-impact fall. That was not like a gentle knockdown from getting backed over or backed into from a vehicle. It would have been more consistent with the fight. He was probably knocked unconscious. Hypothermia sets in. That was probably a contributor to the death. He was probably alive, loses consciousness. He's in the elements. I don't know how cold it was at night. It was something like in the single digits or something. He's incapacitated. He's out there for a long time, and he succumbs to the elements. Those facts, as they were presented at the time, were consistent with being dumped there, perhaps after getting into a fight, perhaps having encounters with other people in the house. There was Apple cell phone data that suggested that he went up and down 3 flights of stairs in that house. It was like 3 stories, a 3-story house. There was like a basement, first portion, second portion. And there was cell phone data that suggested that not only did he go in the house, but he went up and down. And there was like this back exit outside of the basement where it was posited. I don't remember if it was posited at trial, if it was just one of the theories. Well, they could have just had a fight in the basement. They could have dragged him outside in the back and just said, okay, this is what we're going to do. We're going to cover this up. We're not going to say anything. We're not saying nothing. We're going to leave him out here in the elements. We're just going to say that, he was too drunk. And we're going to blame it on Karen because Karen was pissed at him for having, she was pissed at him for a lot of reasons. The voicemails didn't help. She was screaming at him in voicemails and things of that nature. But look, there was a theory of the case that fits. Him walking into a house, getting into an altercation with the people inside the house. There was a dog that seemingly disappeared that was on the premises. If that dog was protecting its owner, it stands to reason that would be a reason for him to attack O'Keefe. It would fit the injuries that was sustained, I think was on his right arm. Why his arm was like shredded to freaking smithereens. He probably hit his head on something hard, causing a skull fracture. Was left out in the elements. He'll sleep it off or whatever. I don't know. I don't know what they were thinking. And that's really the problem with that theory. It's too speculative. I could come up with all kinds of different versions of that movie. And all of them would be believable. The problem is I don't have direct evidence, and neither does Jackson, to tie it to that singular theory enough to introduce third-party culpability evidence. And that's problematical because that would be the best evidence that would lead to an acquittal for Karen Reed. So there is that. Aside from that, one of the bigger controversies with this case was whether or not the evidence was tampered with, whether or not it was planted by the police. Prosecution's like, obviously not. This suggestion is baseless. Contrary to the actual evidence. Well, because the evidence was planted, dipshit. Obviously it would be contrary. District Attorney Morrissey, he goes on record, rejects the notion that there were multiple departments and professionals that were all orchestrating just to frame this one poor 41-year-old lady, Karen Reed. They had asserted that all the evidence was collected. It was legitimately found, even if it was sloppily found. They said that the taillight shards were photographed. near the body. They were bagged properly. Of course, the defense disputes that and vociferously attacked their collection methods. The prosecution emphasized that the scene was chaotic. There was snow. There was rescue efforts. If a piece of evidence ended up in a solo cup temporarily, that didn't do away with the entire investigation, and more importantly, it didn't equal malfeasance on the part of the person who collected the evidence. It was substandard, sure. That doesn't make it inadmissible as evidence, and it doesn't mean he was planting anything. It was under the circumstances. Shit happens in 5-degree weather. What do you want from us? All that to say that, look, it was an imperfect investigation, conceded, but it was not malicious. It was not designed to frame anybody. It was not ill-intentioned in that regard. They note that allegations of evidence planting would require numerous officers knowing about the plan, keeping their mouth shut, having access to things and doing different things, whatever, which is true. It's kind of true. The defense is like, I don't have to fucking prove it. We don't have to prove a conspiracy. We don't have to prove how it was done, which is different in the civil case. In a civil case, you would have to prove that. But in a criminal case, I don't have to prove the freaking conspiracy to you guys. I could just point to the holes in the investigation and say that this investigation was bullshit, which is exactly what they did. I don't have to prove conspiracy. All we have to do is raise the questions about the integrity of the investigation, and they are too numerous to count. But let me give you the highlights. And then they went into this whole thing, which was, the big solo cup was like the big smoking gun with that, right? They talked about Trooper Proctor being fired for misconduct. They talked about the lead. Well, they talked about how Proctor had despised Karen Reed for reasons. He had personal connections to multiple of the witnesses. He was caught sharing investigative info with just regular folks, civilians. I believe he was the one that was making disparaging remarks of Karen through text messages to colleagues, and it was like this really embarrassing set of testimony for him. The defense had talked about how the rear tail light of Reed's Lexus was handled. It wasn't seized until days later, and then of course prosecutors were like, well, that's because it was snowing, dipshit. And when it snows, it accumulates. And when it accumulates, stuff gets buried. And when things get buried, we miss things. But then this miraculous thing happens that the sun raises again on a different day and the snow melts. And inevitably what was missed before is now visible on the ground. And that's the explanation, which is a reasonable explanation, to be fair. But it's still a hole in their investigation. And it raises a lot of questions. The defense had suggested that someone could have smeared O'Keefe's blood or hair on the car. There was a fact that one of the facts was a piece of taillight was allegedly found on John's clothing. That was argued as a little bit too convenient. How is that even possible given the nature of the injuries? And they had brought in experts to talk about how that was a thing. They had talked about the fact if he was kept outside in the deep snow, how is a shard of the taillight ending up in the folds of his clothes? Which I thought was a valid question. But then again, it's not like it's dispositive of the case or anything. They had talked about the digital evidence. There was a disparity in Google search timing from a federally backed expert examining phone data. There's this implication that law enforcement had somehow manipulated the timeline as it was presented at trial. The defense tried to connect the dots. Why did the Canton police chief call out taillight evidence so early? Why did Brian Albert quietly get rid of his dog and the house? Because he did. That house is gone. That dog is gone. Erased from the face of the earth. The defense, obvious implication in all that is because it was a freaking cover-up. Obviously. Brian Albert, Jennifer McCabe, we got to talk about them. I think that Jackson, in trial number 2, if he's going to put this evidence out there, and it's questionable how he's going to do that, because the judge has warned him that, look, unless you're prepared to like implicate somebody with like real hard evidence, I don't want to hear anything about third-party culpability. It's too speculative. You know, you can't just say that aliens might have abducted. Aliens might have been responsible without tying some direct evidence to a spaceship. Come on now. I think it's pretty clear what Jackson has been trying to implicate is that Brian Albert and Jennifer McCabe have been in on this thing from the beginning. Somehow they're involved in the death. He needs to just come out and freaking say it. He needs to say it. Jackson argues that there is multiple people that acted suspiciously. He talks about specifically Jen McCabe. They hammered on McCabe on cross-examination. They talked about all these inconsistencies in her statements. They implied that she had shaped her story to fit the prosecution's narrative, like claiming that Karen told her to do a Google search, deflecting suspicion from her. There was this Google search on her phone. How long to die in the cold? And there was like this typo in it. And her explanation was, well, Karen told me to do that Google search. I didn't do it. I was not wondering how people would die in the cold or if they would die in the cold. It was at Karen's suggestion. That just didn't fly with me. It didn't fly with a lot of people. They also emphasize how Jennifer initially denied remembering any Google search, and then she recovers the memory after being confronted with phone records because she didn't think that search was going to be found. She could have genuinely misremembered, I guess. I don't know. But she didn't look very good on the stand. Brian Albert, the defense insinuates that he had the most to lose. I think that they think that he's the one responsible for the death. I really think that they think that. I think that they believe that there was an altercation that happened inside the home between him and O'Keefe. And if it got out or the fight somehow could be tied back to him, what's at stake for him? He loses his whole effing career. He gets implicated in a murder, obviously. All the things that Karen Reed is facing right now, he would be facing in her place. Obviously, there's motive to cover it up. Perhaps the altercation happens at his home, and if it gets tied back to him, he's going to lose his career. He's going to be implicated for murder. He retired early. I think isn't it the case that he ended up retiring or something? I don't remember if he got let go because of misconduct or retired, but he's no longer. I don't remember how that went down. But there are reasons why he was implicated. I just think that Jackson has stopped short of directly implicating him for reasons. I don't know. But that's what it is. I'm a little bit concerned about how this trial is going to go. They've had some pre-trial motions that I just wanted to run through with you guys briefly as we're preparing for what's coming. And this is essentially it. So they addressed third-party culpability again. The prosecution had moved to limit the defense's third-party culprit theory. And for obvious reasons, like, look, unless you're going to directly implicate somebody with a piece of evidence, then I don't want the defense to be able to just throw out this theory that any one of the people inside of the house was responsible, but it wasn't my client, Karen Reed. That's not fair, and it's not speculative, and none of the evidence supports it. And then the judge is like, well, I'm going to grant that motion in part. So she didn't bar mention to third-party culpability. She just said that I'm not going to allow you to mention specific names. She said that the evidence that was presented the first time at trial, and indeed the evidence that's scheduled to be released this time, this go around, it's still too speculative. And in that motion, the defense was unable to tie any direct evidence directly to a third-party culprit. Massachusetts law says specifically this, that defendants have a constitutional right to present evidence that another person committed the crime, but the judge has to find that the evidence has substantial links to the crime. It can't be too remote. It can't be speculative. And here, the judge likely found that the defense proffer of evidence, they were pointing at several individuals. There was no direct proof linking them, though. It was too speculative. And so you cannot just name these people. There was a case that was mentioned. It was Commonwealth versus Buckham, where the trial judge can demand an advanced showing of a connection before allowing third-party culprit evidence. And that hasn't happened yet. And so therefore, the defense is limited with that theory. They can show the evidence, and they can continue to show evidence in the case. And if somehow during trial that evidence links to a third party, then they can start talking about who these third parties are going to be. But they can't just start bringing up Brian Albert, Colin Albert, Brian Higgins, and all these other people suggesting that they may be guilty without giving us direct links to evidence. And so that's something to look for in this upcoming trial. Another pretrial motion was these Turtle Boy communications. If you guys are unaware, and if you're watching this stream, I can't imagine that you would be unaware of Turtle Boy and his role. He has been all over social media advocating for Karen Read. He was charged with witness intimidation, tampering, I think. He had had extensive communications with Karen Read. There was a pretrial motion specifically about Read's communications with Turtle Boy, and the judge ruled that the data from Turtle Boy from his cell phones is going to be admissible in the retrial. And why is that important? Because it's going to be evidence of consciousness of guilt. Prosecutors, they're going to be allowed to present Read's communication with Turtle Boy, where they were talking about defense evidence, where they were talking about witnesses, and they're going to try to present it as having a guilty conscience. And the judge also approved the use of any proof from those phones of witness intimidation efforts that were related to Read's case. And why is that so important? Because if it gets out to the jury, and the jury thinks that Karen Read, who had these communications with Turtle Boy, was somehow in support of whatever Turtle Boy was doing to try to intimidate witnesses, then it could impact the way that they view Karen Read in the case. Consciousness of guilt evidence is important if you're on the fence. Was she acting guilty? I don't know. Is that the way that a guilty person would act? Is that the way that somebody who was genuinely concerned about the well-being of their deceased spouse would act? Are those actual authentic tears, or are they something else? Consciousness of guilt evidence is something that really wasn't explored all that much. I think the theme of the first trial was the lack of consciousness of guilt because she genuinely had no idea what she did. And I think that thing's probably going to happen again in trial number 2 is they're going to spin as like, look, she was so drunk off her ass. She had no idea what was going on. She may have ran over somebody. She might not have. In this documentary, she asked the question, what if I ran over his foot? What if I clipped him or something? He just didn't know. All those communications are coming in. They're coming in now. And so I don't know if I just don't know what the value of that evidence is going to be for a jury. I genuinely don't. If I was on the jury, what I would be impressed with the most would be the experts coming in to testify that it's not physically possible that he sustained these injuries as a result of being hit by an SUV at like low level speed. What would it have been, like 20 miles an hour? I think it was 21 miles an hour. It was some kind of low level speed. For me, I was convinced of Karen Read's innocence when the experts specifically said, look, it's not physically possible for him to have these skull fractures and all of these other injuries just because he got backed into at 20 miles per hour by an SUV. Not possible. It looks more like he got his ass kicked, is basically what they were saying. And then was left unconscious to perish in the elements. Turtle Boy stuff is coming in. They moved to exclude certain witnesses. There was more motions on tampering claims. The defense motion to dismiss for egregious government misconduct. was denied. While it doesn't directly control trial evidence, well, it was just standard fare. I mean, none of that is really, just basic stuff. Let's go over the timeline. I wanted to revisit some of the timeline because this is what we're going to get into. As you guys recall, take you guys back to that night, January 28th to 29th. It was like the late evening, the morning of, between 9 and 11:30 p.m. It's acknowledged by both sides that Karen Reed, with her boyfriend, John O'Keefe, they go out drinking with friends at the Waterfall Bar in Canton, Massachusetts. The defense agrees. There was no signs of conflict. Everybody was having a good time. They were bar hopping for whatever reason. I don't get the bar hopping thing, by the way. Why can't you just pick a place and stay there? Why do you got to go to all 3-4 different bars? I mean, number one, you go to one bar, you got to buy a drink while you're there. I imagine that you're getting drunker and drunker. The whole bar hopping thing has never made sense to me when I was a younger man or right now. At some point between the hours of 11:30 and 12:15, the prosecution says that Reed and O'Keefe, they visit this second bar, McCarthy's in Canton. Witnesses had noted that there was tension between the two. There was a voicemail that was left at 12:37 a.m. Reed was really pissed off at O'Keefe. The defense kind of downplays the voicemail as just this routine couple disagreement, whatever. It's not really anything more than that. It was an argument. It was a disagreement. That's all it was. Sometime between 12:15 and 12:30 a.m., Reed and O'Keefe, they head toward a house party at 34 Fairview Road. It was the home of Brian Albert. Prosecutors say that O'Keefe is hit by Reed's Lexus SUV. It was during a three-point turn. Shortly after arrival, around 12:24 to 12:30 a.m., it caused fatal injuries. He was left for dead in the snow. The defense confirms the arrival time, but argue that O'Keefe gets out of the car safely, goes into the house, and the cell phone data suggests that he goes inside of the house, goes up and down the stairs, is involved in some kind of an altercation, and somehow ends up unconscious or dead and is left for dead in the snow, succumbing to the elements, or he was already dead. One of the two. At 12:37 a.m., Reed leaves a voicemail for O'Keefe expressing anger, talking about, "John, I effing hate you." The defense says, yeah, she was pissed off. She was drunk. She was frustrated. There was a lot of things going on. There was infidelities or whatever. I don't know, whatever. But it had nothing to do with her desire to try to harm him, which would have been evident from her reactions, her genuine reactions, when he failed to come home, and she was legitimately confused about why he wasn't home, and she was freaking out a little bit. Between 12:45 a.m. and 1 a.m., the prosecution says that Reed leaves the Fairview Road scene, leaves O'Keefe injured and exposed in a blizzard. They claim that her fleeing the scene is consciousness of guilt. I would argue, and the defense argues, that she left. She had no idea that he was injured. She thought he was fine. She was angry. How is that evidence of anything? They say that Karen left unaware of any incident, emphasizes there is a lack of direct evidence placing her there's a lack of direct evidence that suggests that she was responsible for whatever happened to John at the scene. We all know. Between 1 and 2 a.m., sometime between 1 and 2 a.m., O'Keefe is unconscious. He's outside. He's suffering from his injuries. He's hypothermic. The defense argues that O'Keefe is not outside. O'Keefe is inside. He's not incapacitated. Or he might be incapacitated after a physical altercation. The problem is you can't just say physical. They keep saying this physical altercation occurred. We don't have any evidence to indicate with whom, which is what's so frustrating. He has a good third-party culprit theory. He doesn't have anybody to tie it to. And the risk is you try to go for one person, the jury doesn't buy it, and then you just lose all credibility. So it's risky. You can't just name somebody when the evidence is too speculative. Number one, you're going to get objected to. But number two, you just, it's a bad look to try to pull that move at trial and have it go poorly. And so I understand the reticence with all of that. Either way, some point at 2:27 a.m., there's this critical Google search. Jennifer McCabe, while inside Brian Albert's home, searches how long to die in the cold with a typos, Haas long to die in cold or something like that, whatever it was, HOS. She makes that Google search by herself inside the home at 2:27 a.m. and then later claims on the stand that Karen Reed asked her to search on Google specifically. How long does it take somebody to die in cold? How in the F does that fit anybody's timeline? And for what reason in 2023 or 24, whenever, actually I think heard in 2021, in the 2020s, when you have access to a cell phone, why would you text somebody to search for you on Google that specifically? It makes no sense. I mean, if you put on like your Batman hat, I don't know why it's got to be Batman, but if you put on your thinking cap, I guess, maybe Karen Reed was a secret genius and thought that by asking McCabe to input that Google search into her phone, it would be evidence that would be used later that would exculpate her from any theory that she was responsible, because look, it must have been Jennifer McCabe because she's searching for how long do you die in the cold. She must have had something to do with it. That doesn't even fit as it's coming out of my mouth. And so, I don't know. As I revisit these facts, it's just, I cannot reconcile in my own mind and be at peace with any theory of the case why Jennifer McCabe would make that Google search and bullshit that Karen Reed told you to do it. Makes no sense. I'm not buying it. The defense says that the digital forensic timestamp, obviously, I got that wrong. The defense, obviously, they said that the prosecution's response to that was that the digital forensic timestamp misinterpreted. They claim that the search happened after O'Keefe's discovery around 6:23 a.m. That would be awfully convenient for a digital forensic timestamp to be misinterpreted, and it just so happens to coincide with an ongoing investigation. That would be more appropriate. I mean, because look, if somebody's been found in the cold at that point, everybody kind of already knows that he's been found, he's been in the cold. That would be an innocent Google search at that point in time. It's just a weird coincidence that, somehow there was a digital forensic timestamp misinterpretation. And everything else was correct except for the time that Google search was initiated. It was either at 2:30 or 2:27 a.m. or 6:23 a.m. They both tell exceedingly different stories and implicate very different people. At 2:45 a.m., the defense highlights that snowplow driver, Brian Loughran, passes 34 Fairview Road, doesn't see anybody on the lawn, argues that O'Keefe was not outside at that time. Prosecution says, obviously he just missed it because of visibility conditions and snow coverage, which is a logical retort. They literally said there was a blizzard. And if you've ever been in the midst of a blizzard and you're driving on the road, you're not like all that keen on looking at other houses. You kind of have your eyes on the road there. But, so January 29th at between 5 and 5:30 a.m., Karen Reed becomes frantic after O'Keefe's absence is noted. She's obviously expecting him. But the prosecution tries to portray it as like feigned concern. repeatedly asked the question whether or not she hit him. They say that's obviously consciousness of guilt. But the defense is like, bro, she was like blackout drunk. She was questioning because she didn't remember. She was fully expecting her boyfriend to be there, and he wasn't there. Her being frantic is evidence that she was deeply concerned as a girlfriend that was anticipating having her boyfriend be there with her as she woke up that morning. She starts questioning things. And obviously the points of the physical evidence do not support that she ran him over, the whole thing, whatever. Between 5:55 and 6:05, both sides confirm Karen Reed and friends go back to 34 Fairview, where O'Keefe's body is found in snow, in the snow that was covering the yard. The prosecution have witnesses that testify. Reed repeatedly says at the scene, "I hit him." And they say that is a clear confession to the involvement. Or was it simply somebody in the moment realizing that, holy shit, John's dead? Did I hit him? Is she saying it repeatedly as a question, questioning herself, questioning a lot of things? She doesn't have a factual basis in her own mind because she was so blackout drunk the night before to make a confession, to have a consciousness of guilt, which is exactly what the defense says in rebuttal. The morning hours of January 29th, the police discover Reed's Lexus. It has a broken rear tail light. It matches fragments that were near O'Keefe's body. There was a DNA analysis that confirms that there was a match. The defense says they raise questions of possible contamination, mishandling, potential evidence planted by investigator Proctor, who was friends with Albert. Again, if there was a cover-up, it would have been across multiple individuals, multiple departments, and I know that that is a wild story to tell, but the inconsistencies in the investigation, they raise a lot of questions that the prosecution fails to answer. After that, around midday on January 29th, Reed, according to the prosecution, makes a suspicious phone call to her father, William, stating that she's concerned that she might have hit something. They say that reinforces knowledge of guilt, but others would say that she still has no idea what the hell happened. She's still trying to figure it out. And she just, we don't know. We don't know. She's still in this mindset where she's trying to figure out for herself what's actually gone down. So between February of 22 and June of 24, there's this whole investigation. There was a trial that goes from April until about July of 2024. It ends in a hung jury. Between July of 2024 to March of this year, prosecution claims that it has new forensic evidence. There's new vehicle electronic data. There are expanded witness intimidation claims, and that's what we're expecting to see come out in trial number 2. And they're specifically about Karen Reed's communications with Turtle Boy. How that's going to play out at trial, I have no idea. For the defense, they really want to introduce federal experts that dispute the prosecution's forensic claims. They're going to want to emphasize that Proctor's firing was proof of investigative corruption. That's kind of, I don't know. That seems like an uphill battle, but we'll see. We'll see. So there's a lot going on. They're picking juries right now. Let me know in the comments about what you think. Are you team Karen Reed or are you team Commonwealth? Because that's really where it falls. You either think that she's guilty or innocent. I've gone back and forth with this case. To me, there's enough reasonable doubt there to suggest that I just can't possibly see how you have a expert get on the stand, and I'll still never understand how anybody on the jury could have considered anything other than she was not guilty of murder, given that you literally had an expert come on the stand and say that the physics do not support the injuries sustained by O'Keefe if you're telling me that she was hit by an SUV. That doesn't look like what happened. What it looks like is he got his ass kicked. And then the jury's like, well, I don't know. But you never know how juries are going to play this up. I guess we'll see. And we will be doing recaps. I'm not going to be doing play-by-play coverage of the trial, but I will be doing daily recaps nightly, on a nightly basis, on my normal regular show. We will see where this lands. I'm looking forward to it. I'm nervous. I got to tell you, I'm nervous. And I don't have much faith in the Commonwealth or this judge, but we'll see. I love you all. We're about to do Family Law After Dark coming up in just a few. I will see you guys over there. Bye-bye.